Well, thank you very much, Mary, for those kind words and encouragement to buy the book. Thank you for you people being here this morning. It's always a pleasure to collaborate with Mary on these events. So, the purpose of today's remarks is to give you some idea of the basics of record keeping that arise before you name your executor. Once you become aware that you've been named as an executor, and when you're fulfilling that role. And bear in mind, I know Mary's already mentioned this, but these are general comments, and your individual circumstances may indeed require the expertise of a professional, and so I do encourage you, if that arises, that you don't hesitate to seek out that advice. Nevertheless, record keeping is record keeping. So hopefully what follows will give you an indication of what to expect when it comes to record keeping requirements and how to go about fulfilling them. The first set of people I'd like to address my comments to today are those who have not yet named your executor, or perhaps you're thinking of changing that person or those people. I call it the will maker. The lawyers in the room will refer to you as a testator or a testatrix, if you're male or female. I find those words awkward, and I'm an accountant, so I just like to call you the will maker. But as you think over who you might think would be a good executor for you, here are some questions to ask yourself. And for the moment, before you even think about naming your executor, I want to put the spotlight on you. The big question to ask yourself: are my financial affairs in order? Have I taken the necessary steps to ensure that the winding up of my estate is a manageable proposition? So as the accountant here, what steps might I be alluding to? Downsizing. And I'm not talking about moving from the 4-bedroom family home to the 2-bedroom condo. I'm thinking about bank statements. How many bank statements do you have? How many bank statements do you need? Bank accounts do you need? Have you canceled credit cards and memberships that you're no longer using? And what about those investment accounts? Are they kind of, all over the place with 2 or 3 different investment houses? Perhaps it's time to bring them all together. This will not only make life easier for your executor, but it's also a great protection against financial elder abuse, as well as identity theft. The fewer accounts you have out there with your name attached. So still with the spotlight on you, let's consider your general record-keeping habits. Do your habits ensure that the paperwork that trails behind you in the wake of your living is organized and readily accessible? I know Margaret has already alluded to that box that comes into her office. So in my mind, this includes more than just your bank statements and your investment statements that have, insurance, that has purchase price confirmations. But it includes your documentation such as your will and power of attorney documents. A complete list of assets and liabilities. Do not leave this task up to your executor. That's just being mean. You might think, well, I'm only 45, so what would I be doing with making a list now, because I'm planning on living for at least another 45 years. Well, if you make it now and review it every 4 or 5 years, you get into the habit that is something that it's an important piece of paper that you need to update. And as you sell the toys, as you sell the motorcycle and the speedboat, you can cross them off the list. But at least it's there and part of your important papers. Insurance policies. The location of safety deposit boxes and the keys so that access can be had. Original bill of sale, or perhaps more recent valuations of your high dollar assets like jewelry and artwork. Details of loans given to family members or friends. And what's your expectation upon your death for those loans? Do you expect them to be paid back to the estate? or are you willing to forgive them? And I'm an accountant, so I have to mention this. Past tax returns. The CRA does require a 6-year retention period. They can come back and audit you within 6 years. So you want to make sure you have your past tax returns and any supporting documentation for claims you've made in those tax returns. Another piece of paper that you want to have filed is a list of account numbers and the passwords for computer access. If you do some of your banking online. And finally, a list of contact details for any professionals that you use. The accountant who's been doing your tax return for the last few years. The lawyer that prepared your will and power of attorney documents. So now the big question is, you've got all this really well organized. You've got a banker's box. You've got a filing cabinet with all the files appropriately labeled. Whoever it is you choose to be your executor, make sure you tell them about the box. Make sure you tell them where all these important papers are. You want to leave the paperwork documenting your existence in such a manner that your executor will be able to quickly get up to speed on what assets and liabilities you have, ascertain the value on or around the date of your death, and move efficiently towards winding up your estate. The best case scenario, of course, is one where they simply carry on your good record-keeping habits, and they're able to fulfill their responsibilities as executor with little stress and wasted time. Executors who are not able to take steps early to efficiently administer an estate are more likely to end up in the black hole of ungrateful and impatient beneficiaries. Increase the risk of ending up in court trying to justify their actions or lack thereof. And then the money from your estate ends up in the pockets of the lawyers rather than in the pockets of your beneficiaries. So ask yourself, what kind of legacy do you want to leave? I do want to mention here that when you're choosing your executor, you do want to consider their innate ability to be organized, their innate ability to maintain the proper records to ensure that they can account, perhaps to the courts. You know your family and beneficiaries. Is this a possibility? It's a sad thing to say, but money brings out the worst in us. At the very least, are they sufficiently organized and up to date to have the ability to answer the inevitable questions from beneficiaries in a timely and succinct manner? In closing this section of the talk, let me just raise the scenario of someone who has a power of attorney managing their affairs. In this scenario, the person acting as a power of attorney is under a statutory duty to establish and maintain a full set of records of your financial affairs. And while your choice of attorney doesn't have to be the same one as your executor, you do want to consider your attorney's ability to properly keep and maintain the necessary records required by law. Properly maintained records will ensure that a complete set of records is available upon your death. And whether your attorney is your executor or not, a complete set of records is still required. And having them in place will greatly facilitate the administration of your estate, as we'll see as we move on. Let's move on to the next group of people I want to include in today's talk. Those of you who at some point in time know you will be fulfilling this role. We've just listened to the previous speaker who has enlightened us on a little bit of what we have to look forward to. And if you still have questions, then I really encourage you to seek out answers, sooner rather than later, just for your own peace of mind. One aspect of this role that often ends badly is the record-keeping side. Or perhaps I should say it's the lack of record-keeping that results in problems down the road for the executor. Inadequate record-keeping practices results in missed filing deadlines, incomplete information being filed, and inability to respond in a timely manner to questions from the beneficiaries, to name just 3 issues that arise. And while the law is very quick to tell us that we have to keep records, it is rather silent on what exactly that means. Is that a fair comment? It does not address the how-to of record keeping, nor give any guidance on what it would consider sufficient record keeping. There are few resources out there that bridge this knowledge gap. However, Let the Record Show, a practical guide to power of attorney in estate record keeping, does fill this knowledge gap to a large extent. That's why the book was written. And I encourage you to have a look at it during the break or visit us at our website, showmetherecords.ca. So let's spend a few minutes now just highlighting the reasons why we want to keep good records as we wind up the estate, and just kind of what that means. So we've already been told we're legally obligated to. We want to ease our stress. We know this can be a stressful task, and we want to try and minimize that. If we can access the relevant information needed to file the tax returns, the application for probate, if that's required, and the following estate information return, then that's going to ease the stress. We want to maintain good relationships with the beneficiaries. Being able to answer appropriate questions in a timely manner will boost their confidence in us fulfilling this role. And this in turn will likely increase their patience with us through this very long process of winding up an estate. And of course, we want to avoid court. By being able to answer questions adequately and in a timely manner will ensure that the beneficiaries never feel the need to challenge the way that we're handling the estate. So what does record keeping mean? Well, it really means no more than keeping track of the ins and outs of the cash on the bank and investment statements. Often people ask me if they need to use a software program, and I say no. I mean, you don't have to use a program, although using one can make life easier and the job less time consuming when it comes time to sit down with beneficiaries and review what you've been doing, and also when putting together the information for the tax returns. Whether you choose to do so or not will depend on such factors as how much activity there is in the estate and how comfortable you are with basic bookkeeping tasks. Most people may find an Excel spreadsheet package quite sufficient for their means, or while others will find that they need to do no more than simply write directly on the bank statement a description of the transaction. Example, funeral flowers. In addition to showing that you're taking time to identify the types of transactions that show up on the bank and investment statements, of paramount importance is to ensure that you have the documentation that supports the nature of that transaction. Margaret has already alluded to the detail that if you end up in court, the courts will be expecting you to account for every penny. And it's just, I can't stress it enough. Our starting point, of course, is the estate and the estate inventory listing. And I go back to what I was talking about a few minutes ago about how we can make life easier for our executor. Having a list of our assets and liabilities with all your important papers, so that your executor will know with certainty that they're starting off with a complete record, will help them start off on the right foot. The first thing that an executor must do is determine the values on or around your death. And how much effort this takes will depend on the completeness of the inventory that you've left them. Certainly if shares exist, then they'll need to know the value on the date of death so that appropriate capital gains and losses can be calculated for the terminal return. The executor will need to develop an action plan that sets out their plans to redeem, sell, pay out, perhaps maintain items on the list. And the results of these actions will eventually end up on the bank statement. Perhaps the only one that won't would be if shares are being directly transferred to a beneficiary under terms of the will. They'll show up on the investment statement, but not the bank. It's really important that executors keep notes of meetings held with any professionals that they meet with to assist them in the disposition of assets. And if it's been decided to hold on to any items in the short term, then a note in the file explaining why you're doing this might be a prudent idea. Certainly if you change your initial plans, then make a note in the file as to why you've changed your mind. And this is because the executor may very well find themselves having to justify their actions or lack thereof down the road to beneficiaries. And unfortunately, our memories are perhaps not what we would like them to be, what they once were. So let's just get into a practice of making notes. If the will has to be probated, and this will be necessary if there's real estate involved, or if there's large investment accounts that are not jointly held. I've also found that in the last couple of years, banks are getting more particular about saying a probated will, even for modest estates, modest bank accounts. So it's of paramount importance that the executor has documentation to support the value of the estate included on that probate application. Long gone are the days when the government would accept every application without a second glance. The changes to the Estate Administration Tax Act of 1998 that came into effect January 1, 2015, that Margaret has already talked about, allows the Minister of Finance to audit the values of the individual items that make up the total of the estate value. Another question I'm often asked is, how long do I have to keep these records? Because I really want to get rid of them. So we kind of have to look at 4 different parties as we consider this answer. First of all, there's the CRA. And you don't want to be getting rid of any records until you have that clearance certificate. That is a document from Revenue Canada saying that they're satisfied that the deceased person no longer has any tax liability with them. So at that point, if that's the only party we were concerned with, we could get rid of the records. We have the Minister of Finance. If the executor has had to make a probate application and file the required estate information return, we have 2 time frames to contend with at the provincial level. The first is the 4-year window from the time of applying for probate that the minister has to review the values on that application and decide whether they want to audit those values. And unfortunately, the ministry does not have any clearance certificate mechanism like the CRA, so there's nothing to do but for the executor to wait out those 4 years to ensure they're not going to be audited. The second time frame arises from wording in the statute that's been around for quite a while, that should the ministry suspect fraud, omission, misrepresentation, or if you don't file the information return, then an audit can take place at any time that the minister considers reasonable. It doesn't define what it might consider reasonable. However, as you read through the statute, there is a mechanism where you can apply to destroy. You can apply for consent to destroy records. They will usually grant this after 7 years. That's a long time frame to be keeping records. And there's more information on the Ministry of Finance's website if you think you're in that situation. The court is another body that we have to consider when we think about record retention. Is there litigation against the executor, or do you think there could be? You don't want to be letting go of anything. And of course, the beneficiaries. You don't want to be getting rid of any records until you make that final distribution and receive the release form. A release form is them saying, thank you very much for all this money, and I think you've done a great job as an executor, and I'm not going to come after you for any reason. That's the layman's term. I'm sure the lawyers will take 5 pages to say that. So a final question I'd like to ask this afternoon, directed to those who know they will sometime take on this role, is how well do you know the person whose estate you're winding up? Their financial affairs as well as the family dynamics. And I know many people can be very close with their financial affairs, and that's fine. You know, we have a right to privacy. But, excuse me, I really do believe it is incumbent upon the person writing the will and the person who is going to be going to be the executor, that there's sufficient trust in the current relationship. When you're thinking about who to choose for your executor, it must be someone you trust. So that there is sufficient trust in that current relationship that a conversation can take place to ensure that this role, when it finally has to happen, can be conducted with the least stress and time possible. And certainly family dynamics, certainly if your executor is a non-family member or perhaps someone who lives out of town and may not be aware of the intricacies of the family dynamics. Some families have more challenges in them than others, and so for your executor to be aware of those dynamics, you know, sooner rather than later, will help them perhaps think about some strategies of how to approach and deal with those personalities down the road. I'd like to finish today by talking to people who are currently in this role. I'm sure that much of what I've already talked about has resonated to some extent, and by the time we're finished today, you'll all be patting yourself on the back, having confirmed you've established all the right record-keeping habits to avoid the worst pitfalls. To finish, we're going to look at who we find ourselves accountable to in this role, the kind of records we're supposed to be keeping, and what are the key actions that should make up my record-keeping habits. And we'll do this in the context of 2 different scenarios, the straight distribution and the ongoing. The straight distribution is the most common. It's where the terms of the will are such that the assets are going to be distributed as soon as possible. There might be the odd charitable donation, and then the rest of it is being distributed to individuals named in the will. But please don't interpret simple as fast. Have no illusions. The process of administering and winding up an estate, even a modest one, takes a number of months. An executor is probably looking at 18 to 24 months where there's no probate involved. If probate is part of the process, you know, you're probably looking at 5 to 7 years. And that's because of that time frame that the ministry has put on us in terms of their ability to come back and challenge values and to challenge your role. So to whom are we going to be responsible under the straight distribution? Well, of course, we have the CRA. We've got a terminal return to do, plus we'll have 1 or 2 T3 returns, which we call the trust return. And again, you know, record keeping will be so important so that you can make sure that you're accounting for all the revenue that's come in, that you're calculating capital gains and losses correctly on any shares. You're going to have the Minister of Finance, as we discussed earlier, if the will needs to be probated and the administration tax calculated. You're going to want to make sure you have sound source documentation. You want to be able to ensure that one isn't overstating the value of the estate and thereby paying more tax than need be. You want to make sure you have the appropriate documentation in case you're audited. And of course, you want to be able to accurately complete that estate information return. You know, beneficiaries, they're entitled to ask questions. They can ask questions like, have you filed the final tax return yet? When are you collapsing the investment account? When am I getting my inheritance? Why do I have to wait so long? Where did all the house money go? They can say, show me the records. And while the beneficiaries may not be overly zealous with their inquiries, having proper records will ensure that you can answer their questions in a timely manner and with sufficient detail so that they don't become overly zealous. The fourth group is the court, if you have to formally pass accounts. And this may happen if one or more of the beneficiaries become suspicious of you and your actions to wind up the estate. They may have the perception, and that's all it takes, is their perception that you're not conducting the process of winding up the estate with the objective of treating all the beneficiaries in an even-handed manner. Some decisions you're making, they may think, are going to benefit one or more beneficiary to the detriment of another. They may become suspicious that you're funneling money into your own pocket rather than into the estate's pocket for distribution. So good record keeping will allay these concerns. If you're in this role now, then you need to ensure that you have ascertained the values on or around the date of death, and that you have filed away that supporting documentation in a safe place. You also need to ensure that you're keeping track of the ongoing revenue streams if there's investments that haven't been collapsed yet. And if the person was still working when they passed away and they still need to receive their final pay, perhaps a part bonus payment, you need to ensure that that's received. The records you need to be keeping are hopefully much the same that the person who has died left you to carry on with. So we have the estate inventory. We'll have the last couple of bank statements from them, and we'll be able to easily see that the final balances on those bank statements have been transferred properly into the estate bank account. You'll have professional valuations, of course. You'll have the investment account statements. You'll have the professional valuations and appraisals, the ones they left you. Perhaps you've had to go out and seek a couple more. Records of the tax records, the ones from the deceased as well as ones that you've been accumulating, the records of proceeds and sale of estate assets, expense receipts to support all expenditures out of that estate bank account, and of course record of discussions, conversations you've had affecting actions taken in the course of winding up the estate. So how do I do all this? Well, we've talked about documentation. Document. Whether it's a handwritten note, whether you keep the documents in your computer. If that's the case, make sure you're backing up your computer. If your computer has a password, if it's password protected, make sure that that password is somewhere that's accessible. So should something happen to you, the succeeding executor will be able to get into that computer and carry on that role that you've left behind. Be organized. It really doesn't take a lot to have a banker's box, a filing cabinet drawer with files in it labeled bank statement, investment statement, funeral expenses, will, power of attorney. It doesn't, honest. Be prepared to communicate in a timely manner with beneficiaries and government agencies. Be patient dealing with bureaucracies, with government and banks. It can be a challenge. Make sure that you have the proper documentation ready for any meetings. Make sure beforehand you've confirmed with them what they expect you to be bringing. And certainly don't be afraid to seek out competent professional assistance to help you in the estate's administration. You don't have to do the tax return. You have to make sure the tax return is done and filed on time. So use an accountant, but you have to be able to supply the accountant with all the relevant information. With regards to the ongoing estate, and this is where there might be trusts that involve minors or perhaps someone under a disability. There might be a life interest in the estate. An example might be your mother was living in her house. She invited her sister to come live with her. The terms of your mother's will is that her sister is, should your mother predecease her sister is allowed to live in that house until her death. That means that estate is going to carry on until the sister dies. You cannot sell that house until that point in time. So, we had the same considerations as when we were looking at a straight out distribution, but now we're involved with record keeping over a much longer period of time, perhaps, several years, perhaps even decades. So again, we're responsible to the same groups of people under the straight out distribution, but of course now we could also be dealing with the Office of the Children's Lawyer if there's a minor involved. And if there's disability payments, then you'll be dealing with government agencies, at least one. The types of records are all the same that we spoke about before. Bless you. In addition to all of these records, you'll also have documentation from the government agency or the Office of the Children's Lawyer. So you'll just, pick up your folders and label another one and file those documentation when it comes in from those agencies. The same actions that we spoke about are still relevant. You need to document, be organized, communicate. But in addition to this, you do have to prepare yourself for an annual review. And while in reality, it won't actually take place annually, my experience with the Office of the Children's Lawyer, it's a 2-year or 3-year reporting period, but you will have to formally account at some point in time. So you actually do want to do an annual review. You don't want to be chasing down an invoice from 2 years ago when you finally come time to formally account. It's much easier to go look for an invoice that's only 2 months old and get a copy of it than it is to go back to an organization and try and find a receipt from 2 years ago. So I know this afternoon we'll be hearing about common mistakes. So I won't spend a lot of time right now on this. However, I will mention 4 cautionary suggestions. Whether it's a straight distribution or ongoing, don't make statements, verbal or written, without having that supporting documentation. Don't miss filing deadlines. That causes people to be suspicious. It adds penalties and interest to tax payable. So you don't want to miss filing deadlines. You don't want to ignore communication requests from beneficiaries or government agencies. No one likes to be ignored. And you don't want to get behind in your statement or documentation review. You don't want that. You only have one estate bank account. So when it comes in once a month, take the time to review it and make sure that the items that are on it, you were expecting to be on it. And that everything you were expecting is in fact on it. That you have that supporting documentation for the 3 or 4 checks that you may have written during the month. With regards to documentation, if you're getting documentation notices from the government or from the Office of the Children's Lawyer, there may be dates by which you have to respond to them. You don't want to miss those dates. You want to make sure you've read through that correspondence when you get it before you file it away. Make a note in your diary and be sure that you make that deadline. So will this ever end? Yes, it will. It will. It might seem at times that it's a thankless task. After all, who is going to thank you? Certainly not the person whose estate you're winding up. So for all you out there who are going to die at some point, be sure you say a big thank you to your executor before it's too late. Keep in mind that you can have a huge influence on what goes on after you're no longer here. And I'm continually amazed that people don't understand that. But you can. By leaving your estate organized and with good evidence of your own good record-keeping habits, the legacy you leave can be a positive one. For those who have been named an executor but have yet to start, have you had that basic information meeting with the person who has entrusted you with this task? If not, then I encourage you to have it sooner rather than later. And for those of you who may be in the midst, don't despair. This too will pass. However, a word of caution: if there is ever an occasion to dot your I's and cross the T's, this is it. Make sure you keep track of cash in and out with the appropriate documentation. You will want to ensure that you've received the tax clearance certificate from the CRA, and if you've had to file for probate, then you will want to make note of that 4-year window and the 7-year window. You know, that will be the time to start thinking about final distribution, ensuring that you receive the release from the beneficiaries. Know that with a good attitude, grateful for the trust that someone has placed in you, this role can be completed efficiently and with the minimum of stress. So thank you very much for listening.